Good morning, everyone. My name is Clara and I'll be your moderator today. This webinar is sponsored by our Platinum partner, NTI. NTI offers NatRoad members exclusive benefits, such as insuring member vehicles for an agreed value instead of market value, and waiving the additional age excess for drivers under 25, saving you thousands of dollars on claims. To find out more about this exclusive offer and more like it, please check out our website. Now, let me introduce today's speaker, Paul Davies, Exclusive Leader of Productivity at NTC. In this webinar, Paul will help you get up to speed with the Heavy Vehicle National Law Review and break down how it will affect your business. Now, before I hand over to Paul to begin his presentation, may I request that you put your microphone on silent to avoid any disturbances during the webinar. Like always, we'd love to hear from you during today's presentation. If you have a question for Paul, please feel free to type in your questions into the question and answer section at the bottom of your screen. You may send in your questions at any time during the presentation. We'll be answering questions at the end of the session. Without further ado, I'd like to kick things off by welcoming Paul. Paul, your slide presentation, and over to you.
Thank you, Clara. It looks like I'm unable to share my screen at the moment, unfortunately.
No worries, let me just see what's happening. Sorry about that, guys.
Okay, this is working now, so I'll pop
Perfect.
that up. So is that visible for everybody?
Should be.
Hang on,
not
quite
yet. Sorry.
How's that?
Here we are, perfect.
Now. Excellent. Thank you, Clara. Appreciate your help.
No worries.
Thanks, Clara, and thank you to NatRoad, and thank you to everyone who's taken some time out of their morning to join us for this discussion. I really appreciate the opportunity to talk with NatRoad members about the Heavy Vehicle National Law Review. Obviously, a very important piece of work that the NTC is leading at the moment, and so really pleased to be able to come along and talk to everyone today, and hopefully answer a few questions or clarify a few things as we go through. I'll also acknowledge the sponsor today, NTI. Thanks very much for making these sessions possible. Just to run through what I'll talk about during the presentation, it should go for around 20 minutes or so. And we'll have quite a bit of time at the end, I hope, for some questions and answers. We'll just talk a little bit about the process and approach of the review, particularly for those who haven't had much involvement at this stage. And then we'll talk through some of the policy options. So options surrounding duties under the Heavy Vehicle National Law, options around assurance, or more commonly known currently as accreditation, options regarding technology, data and information use under the law, better fatigue management options that we think will make quite a difference, simpler, more transparent access decision-making, safer, more productive vehicles, and a new regulatory structure and approach to actually administering the new law. And there's a few issues that have been raised by NatRoad members already, sort of ahead of the schedule, schedule for this webinar. So I've got a couple of slides in there just to talk about those, and we can talk further about them if we need to at the end. So just to give you a bit of a sense of the approach at the start, we've really advocated from early on for a risk-based approach to regulation for the Heavy Vehicle National Law. It's very much the way regulation is heading, and our assessment of Heavy Vehicle National Law is it's not very well aligned with a risk-based approach to regulation. There's a huge amount of prescriptive requirement in the Heavy Vehicle National Law, a huge amount of administration, and really what we've advocated is that it should be aligned with minimising risks and reducing harms rather than focusing on processes and form filling out. So the goals of the law are to be a modern law that provides a flexible risk-based approach to empower industry and government to take advantage of, well, let's face it, current and future innovation and technology opportunities, and improve safety and reduce costs so as to benefit the community, industry and governments. And we've really framed this idea of a risk-based regulation around the concept of a safe and efficient journey. If you really distill it down, what is the Heavy Vehicle National Law about? It's about making sure that heavy vehicle transport operations are safe and efficient and productive is the language in the objects of the law. And so we've broken that down a little further into safe driver, which you could probably talk about safe people and practices. So that's making sure that people are fit for work, they're authorised, competent, operating safely, that sort of thing. A safe and efficient vehicle so that it's safely loaded, meets standards, it's roadworthy, all that sort of stuff. And then a suitable route, which is matching the vehicle in combination to the route so that the mass and dimensions are acceptable, public safety is there, but importantly that we get productive and safe use of road infrastructure. So where are we at in the process? The process actually kicked off in late 2018. Ministers approved the Heavy Vehicle National Law Review Terms of Reference, and that was our formal kickoff. But we actually had a bit of a discussion with a lot of people, including NatRoad, of course, ahead of the start of the review to get a sense of what's important. We built the terms of reference around that and put out 7 issues papers in 2019. And the goal of those really was to seek industries and others' views on what the key issues for the Heavy Vehicle National Law are and what you would like to see in it. We had a huge response on those. Hundreds of submissions came into those 7 issues papers, which we are genuinely thankful for. And many of them are from industry, a huge buy-in from industry, which shows that there's a lot of interest in this space and some great ideas out there as well. We started to put all that together in late 2019, gave transport agency heads a bit of an idea of what we've found so far and some of the key ways we could take forward to make improvements. And in November and December last year, we brought everybody together, industry, jurisdictions, police and the NHVR, into workshops, several workshops, to identify some potential policy options that we thought might be worthwhile progressing. So that was a very useful exercise. And in the several months that followed that, we developed those up into a set of options. Not all of them are options that can work together. We want to analyse alternatives, and that's done through a regulation impact statement. So the consultation regulation impact statement was published in June, and because that's a 200-page document, quite a heavy read, we also published HVNL 2.0, which is sort of 20 pages or so. A lot of the pictures you'll see in this have been drawn from that. It's a bit more engaging and kind of explains what a future law could look like. Now, it's not for the NTC at this stage to be saying what it should look like. These are just options, and that's why it's a consultation RIS. This is a really important part of the process from now until November, and that is for us to consult on those reform options that are presented in the RIS. We're inviting comments back. NatRoad's been very proactive in that process as well, in providing some feedback so far. And in May of next year, we'll take all of the feedback we receive it'll be from jurisdictions, the regulator, industry members, others, and make a set of policy recommendations to ministers. That will involve essentially a decision RIS, which is the same concept as a consultation RIS, but with the preferred option outlined and analysed, along with an implementation plan for ministers to make a decision on the reforms that they'd like to see in the new Heavy Vehicle National Law. It's very important for us to make sure we have industry's views in helping to shape those, and ministers will be very keen to know that we have considered them properly. So if I move into some of the policy options that we've explored in the RIS and the HVNL 2.0 document, fundamentally duties are a pretty core part of the Heavy Vehicle National Law, of course. At the moment, the primary duty applies to those parties in the chain of responsibility who are defined parties. Now, that's been recognised by a number of people in industry and elsewhere, that there are people who can in fact influence safety who aren't listed in that chain of responsibility. Now, there's a few options on how you deal with that. You could attempt to expand the list of chain of responsibility so that there's a recognition that there's new parties in it. But the flip side of that is that you'll always end up with people who can influence safety who aren't listed in there. The alternative is to go to another parties who influence safety type approach, which doesn't specify. But there's benefit in specifying those who clearly do. So one of the options we've got there, and what's illustrated on the screen, is essentially a hybrid approach where the primary duty, with some clarifications I might add around what it should encompass, could be extended from the to strictly the chain of responsibility parties to also include other parties who influence safety. And it would only apply, of course, to the extent that they do influence safety. And so parties that might be caught in that space might be vehicle repairers, for example, who have a pretty high influence over some aspects of vehicle safety relating to maintenance, but not more broadly than that. We've also had a few parties suggest that driver safety duty would be a useful thing to include. We've framed an option where the work health and safety duty might be applied to drivers through the HVNL. That means no extra obligations on drivers. We don't think, the chain of responsibility was set up to recognise that drivers are certainly not the only influence over safe operations. By having a work health and safety style duty, it would allow the regulator under the Heavy Vehicle National Law to enforce that duty, but wouldn't impose new obligations. I'll move on to assurance. This is really about recognising that not all operators are the same. In fact, there's an incredible diversity of heavy vehicle operations and operators in terms of vehicles, what's carted, where people are operating, the scale and size of industry and capability of particular operators. So we think that assurance, which is called accreditation under the current law, can actually play a bigger role in helping to recognise that operators ought to be able to manage risk, which is the key thing, to the extent that they are able to show that they are effective at doing it. Many operators, of course, are the most effective at risk management because they know their operations better than anyone else. And so more capacity to manage their own risks is something that we think can be achieved through an enhanced assurance approach. So if we look at this picture here, I'll just talk through what it means. When we talk about risk management, there's essentially, an oversight role, identifying the risks, treating the risks, and actually implementing those treatments, those controls for the risk. And we have argued that the more an operator is able to advance, if you like, through an assurance regime, the more they can demonstrate that they can actually take on more of that risk management role. So if you look at the far left of this diagram, where an operator would only be responsible for implementing controls, it essentially means governments and the regulator define what needs to be managed, how it's to be managed, and tell you exactly what to do it, and then the operator goes and does it. When you get towards the right end of the diagram, in fact, what you're saying is that operators are moving to a more collegiate, co-regulatory type model where you are identifying the risks and how they should be managed yourself. And so it brings an alternative way of complying that is probably more suitable to your particular business and would deliver at least the same level of risk management and harm reduction. We've also got in there this concept of enrolled operators. And now that's an idea that we've floated for a few reasons, which I'll sort of touch on as we move through the presentation. But for the regulator to have an improved visibility of operators can in fact open up the door for some alternative compliance methods for operators as well, and it helped the regulator move towards a more risk-based approach to regulation. Now that would be, the way we framed it would be an opt-in thing. You wouldn't need to do it. It would be a very low cost thing to do because it would simply be a nomination. It's not a standard to be met. But it does in fact open up the door to a lot of flexibility, which we think could be really beneficial. Another core aspect of the reforms that we're analysing is technology, data and information. It's of course the 21st century and data is king. And at the moment, the Heavy Vehicle National Law has a very low level of data recognition, if you like. And there's a real lot of opportunity that's probably being missed as a result. We've got here a pretty sort of simplistic diagram, but just talking about the concepts of clarifying in the law that information can in fact be shared between all parties in the law without any sorts of problems. At the moment, there's nothing that really precludes that from happening, but it's not overt in the law, and jurisdictions and the regulator, for example, have set up memoranda of understanding to be able to share the data properly. We think that can be built into the law a lot better. But also, of course, with data, there's a lot of sensitivity, and particularly when we start talking about things like telematics data, where it's not even really offering and volunteering data so much as it almost is a surveillance type tool. And therefore, there needs to be a lot of protections around that. At the moment, the Heavy Vehicle National Law focuses only on the IAP. There are plenty of other products out there that could be of great benefit to industry that have a different focus than a sort of non-compliance and enforcement type measure as the IAP does, which could open up a lot of access opportunities as well. Certainly in some of those workshops in late 2019, we found a lot of agreement between operators and road managers that if road managers knew more what was happening and operators were quite happy to share that, they would potentially be able to open up more roads for access, or at least be able to better manage their roads so that, that the roads being heavily used are proactively flagged for increased maintenance effort. So there's a lot of opportunities here, we think, that that could be expanded upon and made use of in the Heavy Vehicle National Law, as long as those appropriate protections and assurances are there. Fatigue management was a really big issue that we heard from, of course, and straight away when we looked at this through a risk lens, we said, well, it's not so much the vehicle, which is the current criterion for what fatigue management requirements are needed, but it's the driver more so. So we've put forward some reform options that really shift the focus away from what type of vehicle is being driven and more towards what is the risk profile of the driver who's driving it in terms of fatigue. We've also looked at simplified record keeping for drivers and operators. It's no surprise to anyone, I'm sure, that the diary and the record keeping requirements for fatigue are considered quite a heavy burden for a lot of operators and a lot of drivers particularly, and they see it as quite a high risk for administrative type offences and penalties and that sort of thing. Simpler work and rest hours. The current work and rest hours are pretty complicated, something like 55 distinct rules. And when we went through and had a look at it, we think there's a confluence, if you like, of trying to have certainty but flexibility as well. And we think by unpacking those concepts, we can actually get a really simple set of work rules, work and rest hours that will work for most operators, but then provide some new flexibility for if you like, the 20% of operators or so through regulator approved schedules. And this is one of those areas that I link to enrolment. So as an operator who would nominate themselves would potentially have access to different schedules. There might be a generic schedule, a general schedule available to all operators, but by nominating use of another schedule with a regulator, you could move to something that actually suited your operations a lot better, that was equivalent or comparable risk and would be approved by the regulator. So it could even open the door for some innovation with developing some of these schedules. New fatigue management options. I think it's important to note that work and rest hours is a proxy for managing fatigue. It's, time expended certainly correlates with fatigue, but it's not actually fatigue. And there's a lot of new technology emerging, which industry has been quick to adopt, and quick to adopt for safety reasons. It should be absolutely acknowledged that the main role in delivering safety on the road is through industry, and industry has been very proactive with that in adopting this technology, despite the fact the current Heavy Vehicle National Law doesn't recognise and give any sort of credit, if you like, for using this improved technology and installing systems that better manage fatigue of drivers. So we think the new Heavy Vehicle National Law certainly should be opening up to that technology and other approaches, including safety management systems, which are at that far right sort of co-regulatory model end that I was talking about. Now that really moves right away from having that prescriptive, you'll manage fatigue through work and rest hours, and here's what those hours are, to a system where an operator would reach an agreement with the regulator that the way they've proposed to manage fatigue is in fact an effective way, and they would be able to demonstrate that. I don't know, to be quite honest, I don't know how far the political appetite might go on getting completely away from work and rest hours, but certainly the system we're proposing could move you away from having any hours related at all. A driver medical standard, just recognising there that capacity to manage fatigue does have some underlying health questions with it, and while there is the assessing fitness to drive guidelines, it's not the same as a health assessment standard, and it's not something that we can expect operators to do in a way that is scalable or makes sense at the scale of a single operator. And certainly you want an equivalent standard for all operators in that sense. So that would be a supportive option there. And also a right to stop for drivers if they're not fit to work. This is something we heard a lot from drivers, that despite the fact that the Heavy Vehicle National Law does impose a duty on operators and drivers so that drivers don't drive fatigued, it's a blurry edge. It's a difficult thing for them to push back on in some cases. Certainly not for the best operators, but in some cases this is an issue. And this is the other side of the coin, essentially, which is protections to the driver if they do genuinely feel like they are unable to continue. Simpler, more transparent access, obviously another big area of interest in the review so far. Really the main areas of concern centre around permits and the process for getting them. They can take a long time, they can be costly and potentially be quite restrictive. So there's, I guess in a tactical sense, there's two main areas we've looked at here. The first is to reduce the number of permits, and that means enhanced general access, more vehicles in the general access space, but also a continuing transition and an encouraged transition towards notice-based access. And we've also got some other options in there for other access authorisation methods that would be as of right type access, so that permits become the unusual way forward rather than the more normal way forward. But where it does come to permits, expedited access decision-making based on risk and precedent. So the law actually does have some expedited access decision-making powers currently, but they're quite limited, and we think those can be expanded so that similar vehicles or lower risk vehicles can be taken as consented to access roads where they've been approved in the past. Revised process and time limits. The process itself is in the law, and the law is not quick and easy to change, and it does have some funny little loops and dead ends and things like that. It certainly needs fixing, and time limits in there are something that has been raised as a bit of a bugbear for those seeking permits, with up to 28 days, and when the clock starts and that sort of thing can make permit application a long process. Allowing delegated decision making. So a lot of road managers have told us that resourcing is a real challenge for them, and it's not so much that they have any concerns with the vehicles accessing, but the fact they just need to go through it and make sure that that's okay. At the moment, the law requires them to provide a consent before the regulator can issue a permit. We think the option of a road manager saying to the regulator or to that they delegate that consent for certain circumstances could be a useful thing, and certainly a lot of road managers have said that they may delegate that to the regulator themselves. They may delegate that to the road authority, the state or territory road authority, to help make those decisions for them. So that's something that could help speed up the administration of it all. And also a national approach to accrediting pilots and escorts. This is something we certainly have heard from heavy haulage, oversize, overmass operators, that the issues crossing borders with large loads can be quite substantial. Safer and more productive vehicles. So the performance-based standards vehicles are known to be safer and more productive vehicles, and what we can do to encourage more of those will deliver benefits accordingly. A national risk-based inspection regime, so that recognises that we again should be looking at vehicle inspections according to risk rather than fixed schedules aligned to registrations as the only way that's done, and for that to be varied around the country as well. Fast-tracked approvals for wider and safer vehicles. So that's a recognition that a lot of particularly, if you like, rigid vehicles that might be available in broader markets aren't available in Australia because of our particular dimension restrictions. So there's an opportunity there. And one thing that's been raised with us is an extra metre over and above what would otherwise be allowed for sleeper cabins, potentially for those operators in remote areas, but where it's particularly important for operators who rely on resting in the truck for fatigue management, driver fatigue management. So having that extra capacity, recognition that there's some real safety benefits that can come with a well-rested driver, of course. In terms of a new regulatory structure and approach, we think the law can be made a lot more agile. There's a lot of detail in the primary legislation that doesn't necessarily have to be there. And if it can be pushed down into regulation, or better still into other instruments like standards and codes of practice, then it allows for more quicker updates when the time's required, particularly things that relate to technologies and processes and business models, which are constantly evolving, and the law really just can't keep to speed with that sort of thing. Better targeted enforcement efforts. Now, changing the law doesn't change the approach that regulator or police will take. We have to sort of recognise the limits that we have there, but what we can do is set the law up so that it's not focused on this administrative type breach and is more focused on risks and harms, and equally penalties and sanctions aligned to risks and harms. So that there's quite a number of examples in the heavy vehicle national law where there's fairly heavy penalties for what really isn't inherently a safety risk. And yet the flip side is that there's some things that are quite a safety risk that have quite light touch penalties associated with them because they're not well aligned. Now, I'll just move into answering a few of the questions that I've kind of had raised ahead of the presentation, and of course we're happy to talk more after this about that. One of the things raised was around the remote zone option. What's this really all about? I've got here a little map of Australia that was in the issues paper where we first mentioned this, and you can see the white parts of that map actually have literally 1,000th the population density of some of our major cities. In fact, a little tidbit that I threw around when that issues paper came out was that Greenland is more densely populated than the white parts of this map. So clearly there's a huge diversity of operating areas, and by having a defined remote zone rather than attempting to define specific zones on a more bespoke basis, it allows a fairly quick way of looking at a risk-based approach for operators in more remote areas. Now this white isn't meant to represent that. I'm just showing this as a population density to highlight the difference. We haven't set a specific remote zone, but you imagine a bit of correlation with what's in that map there. What it could do is have alternative fatigue arrangements potentially that are related to it, or allowances for vehicle standards or size that couldn't be allowed in non-remote areas. So it's an option that I'm certainly keen to hear industry's view on it. Some in industry have told me that they're really keen to see this, and it might offer some opportunity. I don't want to over-egg what we can say it will do, but it might offer some opportunity to bring a lot better alignment to fatigue management requirements, particularly in non-participating jurisdictions as they re-enter participating jurisdictions. Another one was around assessing costs and benefits. The consultation RIS, we've taken a qualitative view to how we have assessed options in that. There's a couple of reasons for that. The first is that we put so many options in there that we wanted to just present them, if you like, as options in their own right, and we are genuinely consulting on them. We also didn't want to put a hard number against costs and benefits where we weren't able to do so. We're obviously working on improving that, but I didn't want to put a claim out there that something would deliver X million dollars in benefit, only for that to be seen to be either over optimistic or over pessimistic. I'll stress the point as well, it's actually quite a valid way of doing a regulatory impact assessment to use qualitative methods. We have to meet a certain standard from the Department of Premier and Cabinet, Prime Minister and Cabinet, I should say, on what a RIS needs to achieve to be approved, and this one was. But as I said, it's we are certainly working to work up some of these, because when we start bringing the alternatives together in a decision RIS, it's ideal if we can support it with both cost benefit analysis, but also other quantitative analysis. Break-even analysis is an example of a pretty valid way of looking at costs, and qualitative analysis as well is important. You don't want to simply end up with a numerical basis. You want to actually have something that's taken a broader consideration. So we have invited people to submit data sources if they are able to highlight some for us, because we want to use the best data we have available. We have some, of course, but there might be more up-to-date data. So if there's anything people can alert us to, we're very keen to hear it. We also asked a question around fatigue and access. As I mentioned in the presentation, pretty high priorities for industry. Can these reforms be staggered? In other words, can they be brought on a bit quicker? The answer, I suppose, is yes and no, and it's in part because of the stage of the process we're at. So what I've talked about today has a lot of dependencies across the reform proposals. So particularly assurance, data and technology, duties reforms could actually play a really big role in opening up some of the fatigue and access opportunities, the bigger ones, in fact, opportunities there. So there might be some things we can do a little quicker, but without those sort of broader and more fundamental changes, those will be quite limited. What we intend to give ministers in May is a full policy reform picture and an implementation pathway for sorting out some of the other matters that need to be sorted out on the way through. But of course, you know, the goal is always to deliver benefits as soon as we practically can. And other issues not covered in the consultation RIS. So typically a consultation RIS talks about options for reforms that can impact industry and community operational and compliance costs. Certainly we invite comment on issues that ought to be included, or issues that need to be presented to ministers in May. Some of the issues, in fact, many of the issues still need to be dealt with after a broader policy reform is settled. For example, you really can't set penalties and sanctions until you know what the law will require. You certainly can put forward concepts of aligning them to risk, which is something we've been fairly clear upon. And the implementation plan will set out progressing these items. One thing is, I must stress, the NTC is absolutely required to consult broadly with industry and others, and we value doing it. We get great results out of doing it. The better we do it, the better the results. So we want agreeable and workable policy to go forward. We're not looking to put forward something that industry isn't going to find workable. So that's it for the presentation. I probably did take a little longer, I apologise. The hvnlreview.ntc.gov.au website is there, and also our email is there. Do feel free to contact us outside of this session as well if we can't quite get to your question today. But I'll stop sharing my screen now, Clara, and hand it over to you and to those joining us in the webinar.
Perfect. Thank you, Paul. So I'm just going to quickly have a look at the questions that we have today. Right, so the first question is, what can be done besides changing the law to drive safety and productivity?
That's a good question, Clara, and there's definitely a lot of things that we recognise can be done outside of the law. So that fixing the law is not a panacea. There's a lot of other things that can be done, and there's a lot of things that can be done in the current law as well. So access is one that I often cite in this space, and it's one that industry has cited as well. Operators in Tasmania have been curiously sort of happy with the access regime, and the more we looked into that, we realised that the Tasmanian Department of State Growth has done a lot of work in actually doing a lot of pre-consenting, if you like, of the roads that they manage. So industry is able to get quite a quick turnaround on permit applications and that sort of thing. Now that's done under the current law, and so it can be done. What we want to do is to encourage more of that type of proactive approach through changing the law to make that work a lot better. But there's a lot of things that will need to support the law to deliver benefits. The approach of the regulator, the approach of enforcement, those things aren't dictated to by law, but need to work hand in glove with the law. There's also, particularly with access, it's probably a fairly obvious one that strategic funding of roads and priority routes is a really important one to help drive the safety and productivity.
Great, thank you so much. All right, so another question we have is, can the future HVNL reduce third-party auditors' operations are having to do?
Yeah, this is one we hear a lot from operators as well. The chain of responsibility reforms in 2018 have resulted quite unusefully in a lot of auditing going on between some consignors or consignees and operators. Sometimes not even operators that they're contracting, but just having access to their sites, as though that's the way to discharge their primary duty. It's very difficult to, besides education, to say that sort of thing can't happen, because that's not actually an artifact of the law. It's just a response to it that we don't think is a very useful one. But that said, we think that there are some opportunities to offer protections to operators through the assurance scheme, such that an operator who's got an assurance scheme in place that's been properly audited and all the things that would come with an assurance or accreditation scheme, that can offer them protections against other audits, essentially, and can be relied upon by other parties as being a valid thing. So at the moment, that's not being recognised properly. We think there's an opportunity to strengthen that in law, so that there is some protections for operators who are in fact assured they can do one set of audits, and those are sufficient to demonstrate that they are in fact a safe and a compliant operator.
Great, thank you so much, Paul. So that's actually all the questions we have for today. And yeah, thank you, Paul, so much for today, and thank you everyone for attending today's webinar. If you have any other questions, please send us an email at info@natroad.com.au. Please note that this webinar will be uploaded to the website and the recording will be sent to you via email. Yeah, so everybody, once again, thank you for joining us today, and have a great rest of the day, and thank you so much to Paul.
Thank you, Clara. Thanks, everyone.